Hello and welcome to CACET Sample Questions for Exam Legal Aptitude. I am Company Secretary Alok and we are solving the Legal Aptitude MCQs for CSEET exams. I have already done around 14 videos. Please have a look at it. This is the 15th video. We have solved every CSEET sample question for exam. Let us take a look at this question. Which of the following are the functions of the Institute of Company Secretaries of India? So the options are conduct elections of the Council of the Institute. Yes, ICSI only has to conduct elections, others can't do it. Regulation of training of students. Yes, all of you are studying CSCET. You are a student of CSCET. Then you have CS Executive. Then finally CS Professional. So that is ICSI job. Examination of the student, yes. So that means the answer is all of the above. So all of the above is the duty of the ICSI. So that is the first question. Let us go to the second question. According to the Constitution of India, all the citizens shall have a right to practice any profession or carry on any occupation, trade, or business. So this is what? Do we call this as a statutory duty, a fundamental duty, a voluntary duty, or fundamental rights? So what is this? So what are they saying? Any citizen can do any job or they can do any of their own business. So it is not a duty, correct? It is a right. So the right answer is right. So fundamental duties come under Article 51A. There are 10 fundamental duties. But this we are talking about the right. So the right answer is fundamental rights. If you have any doubt, let me know in the comments. I'll be happy to reply. Any doubts, just comment on the video. We reply to every single comment. Next we have under which of the following articles president can impose presidential rule. So unfortunately this is a memory question. See, in CSEET legal aptitude you have two kinds of questions. One is memory question and one is concept question. So memory question you can't help it, you just have to remember. And here the right answer is Article 356. Article 356 is an article where the President of India can impose presidential rule in a state wherever there is any state of emergency or there is a problem of security and safety of that particular state government. So presidential rule can be there. That time, if presidential rule is there, the CM and others don't have the powers. The President of India will have to function. Or sometimes if there is a constitutional issue, for example, the CM has resigned and there is no party which can form the government, in these kind of scenarios presidential rule will be there till election is conducted and the election is completed. Every promise and set of promises forming the consideration for each other is called dash. So every promise and every set of promises consideration for each other. Is it the offer? No. Is it none of the above? I mean, that option is only wrong. It should be in the end. Proposal? No. So it is a promise and set of promising forming consideration for each other. So each other means at least there should be two things. So the right answer is agreement. Please remember, in offer there is only one person. In proposal there is one person. But in agreement there have to be two person, right? You will offer something, the other person will accept, that becomes an agreement. So every promise and set of promises is called as an agreement. Hope you got that. Next, doctrine of consensus ad idem. So in the Indian Contract Act, we have studied meeting of minds is consensus ad idem. Is it going against each other? No. Is it taking consent from the party? No. None of the other? No. It is meeting of two minds. So whenever there is meeting of two minds, then you have agreement, and then after that, if it is enforceable by law, we call it as a contract. So meeting of two minds is first, then we have an agreement. The agreement should be enforceable by law, then it becomes a contract. Okay. So I hope you are getting it. Do give a thumbs up if you're liking this video. Next we have a question which is based on a principle. The consideration or object of an agreement is lawful if the court regards it as opposed to public policy. Every agreement of which the object or consideration is unlawful is void. So this is a principle which says that if you're doing any sort of contract and the object of the contract means the purpose of contract itself is unlawful, then the contract is void or it does not have legal sanctity, legal validity. Okay, that is what it means. Now we have some facts of the case. A promises to obtain for B an employment in public service and B promises to pay 5 lakh. So it is almost like a bribe. To which of the following is correct? So what is happening? There is one person telling that I'm going to get you a government job. You just pay me 5 lakh rupees. So what is it? Which is correct over here of the following? So please remember, consideration should be lawful and not unlawful. There is a voidable contract between A and B. No, because it is completely unlawful. It's not about voidable, it is void. Because here we studied the concept very, very clearly. So as you can see, we have studied here when consideration, the object is unlawful, the contract is void. So it cannot be the first option. There is an agreement between A and B which can be enforced by the court of law. No, it cannot be enforced because it is void. There is a contract between A and B. There is no contract because there is void. There is an agreement between A and B which cannot be enforced by the court of law. Exactly. So it is not a contract, it is an agreement, but it cannot be enforced by court of law because it is void. So the right answer for this question is answer is D. So there is an agreement, but that agreement is not lawful, and because it is not lawful, it becomes void. So the principle is this: consideration or object of agreement is unlawful if court regards it as opposed to public policy. Every agreement which the object or consideration unlawful is void. So since it is void, there is an agreement but court cannot enforce it because it's unlawful. Okay. Next, we go to the concept of turpis contractus. What does it mean? Does it mean at the proper time? No. Does it mean under silence? No. Does it mean an infamous contract? No. The correct one is immoral contract. Turpis contractus is not an English word, it's a Latin word, and it means an immoral contract, a contract which is against the societal norms. It is immoral. So anything relating to adultery, these kind of contracts are immoral and it is not enforceable. Next, we have fundamental rights mentioned in Constitution are borrowed from where? Where have the fundamental rights been borrowed? If you studied properly, it is the US Constitution, not British, not Canadian, not Russian. The confusion is British. You may get confused with British because India was a British colony, so you may get confused, but the right answer is the fundamental rights concepts was borrowed from the US Constitution. Next, memory question again. The Supreme Court of India comprises of Chief Justice and dash other judges. So the correct answer is 33. So you have to remember it. So total it is Chief Justice of India plus 33 judges. So it will be totally 34 judges including CJI. But here they are saying Chief Justice and dash. So the answer is 33. It's a memory question. There's nothing much for me to explain. Okay. Domestic arrangements between husband and wife is not a contract under the Indian Contract Act. Why? Domestic arrangement is what? It is a private conversation between husband and wife. So what is it? Is it a contract? Why? Consideration has happened? No, not for that. There is no consensus. Of course, there is consensus item. There is specifically excluded from Indian Contract Act? No. But there is no intention to create a legal relationship. It is a private arrangement. So the right answer is D. Domestic arrangement. That means any agreement between husband and wife is not a contract because there is no intention to create a legal relationship, and the arrangement is domestic arrangement. It is not a commercial arrangement. Husband and wife can even do business, but it is commercial. But here we are talking about the word domestic. Because word domestic is there is no intention to create legal relationship. Okay. Then you say, does it mean husband and wife cannot have a contract? Of course they can have. If it is commercial in nature, you can. So please don't get confused. Husband and wife can. So let us say husband has one car and he wants to sell it to his wife. Yeah, you can. The wife can give him money and you can sell They may only use it, that is secondary. But they can do if it is a commercial arrangement. If it is domestic, they can't do it. It's not a contract. Constitution of India is celebrated on dash. So Constitution of India is celebrated on dash. Obviously the answer is 26th of November. That is the correct answer. It is not January 1st, it is not 2nd October is Gandhi Jayanti, Independence Day is 15th August, you know that very well. So the answer is 26th November. So even if you don't know the answer, you can eliminate the wrong ones, then you'll get the correct answer when it is celebrated. Constitution Day, 26th November. According to Constitution of India, all citizens shall have the right to practice any profession or to carry on business or trade. So this is a fundamental right. They've repeated this question. It is a fundamental right. Tort is what? Tort is a civil wrong. We know that very well. It is not civil and criminal. It is not criminal. I don't know why first option they even none of the above. That's a printing mistake. So civil wrong. Tort is a civil wrong. You know that this is the most basic thing about torts. Okay. Which article of Constitution provides that all laws in force in the territory of India immediately before commencement of Constitution, whether they're inconsistent with fundamental rights, shall to that extent inconsistent be void? So this is again a memory question. It is Article 14 which talks about inconsistency of the laws. Which article of Constitution of India provides no person shall be deprived of his life and personal liberty except according to procedure established by law? So no person shall be deprived of his life or personal liberty except according to procedure established by law. What is it? So the answer is Article 21. Article 21 talks about it. Dash is not a writ under Article 32 of the Constitution of India. So habeas corpus is a writ, mandamus is a writ, quo warranto is a writ, ubi jus ibi remedium is not a writ. Where there is a right, where there is a remedy. Where there is a right, there is a remedy is ubi jus ibi remedium. It's not a writ. It's a separate concept. Writs are habeas corpus, mandamus, quo warranto, certiorari, right? So these are the writs which we have. A stranger to a contract dash sue both under English and Indian law for want of privity of contract. So stranger to a contract cannot sue. Stranger to a contract cannot sue both English and Indian law. So it is any one. Okay. Last question which is there in this particular video. If any default is made in holding AGM of the company and every officer shall be punished with fine. So this is again memory question. I don't know why they have asked this. The answer is 1 lakh. But I hope they don't ask such questions because they should not be testing your memory. You can always refer the BEAR Act when you are a company secretary. But here they have asked the memory question, so we have just covered it. So that was the video where we covered quite a few legal aptitude CACET sample questions. Please do subscribe to Excel Academy and give a thumbs up to this video. We have sample questions for all subjects of CACET. All our teachers have recorded the sample questions. You can get it for free on the YouTube channel. So with that, we'll end this video and I will see you in the next CACET sample questions for exam for legal aptitude.